All right, so for anyone that's curious about where the name COVID-19 came from, it's really just an abbreviated version of coronavirus disease 2019. I will say that as of this morning, April 1st, there are 870,000 infections that have been confirmed in at least 170 countries and territories, which is pretty staggering considering yesterday morning it was just at 101,000. So it is alarming at the rate that this pandemic is moving along, and it's important that we take a lot of the precautions, which is what I'd like to just end on with next. I'd be remiss if I didn't remind everyone that there are simple things you can do to keep yourself and others healthy. Funny enough, my last line about this was that now that I've told you a bunch of stuff that you already knew, let's get into the meat of the webinar. So, the Families First Coronavirus Response Pact. Let's talk about an overview. March 18th, President Trump signed into law the FFCRA. Act was created to assist employees affected by the coronavirus, and it applies to employers with less than 500 employees. So there's quite a range of businesses that will be affected and have to participate with eligible employees within this new act. One key change is that the start of the date itself was supposed to be for tomorrow. Originally, the act was supposed to take effective April 2nd. However, the date was pushed up to April 1st. Not an April Fool's joke, as much as we'd all like for this to go away. But what I can say is that the Department of Labor gave no reason why it chose to move up the implementation by 1 day. There was speculation that it was done to line up the effective date of the law with the calendar quarter, which does make some sense. So the provisions will apply between April 1st of this year through the end of the year, December 31st. The FFCRA does include sections that apply to employers such as paid sick leave for employees impacted by the coronavirus and those serving as caregivers for individuals impacted by the virus itself. While the Act contains several other provisions that increase funding for some different benefit programs you may be more familiar with, the idea of this webinar itself today is to highlight those which affect the employees, which is a lot of people that are on this call today. So there are two key provisions that I want to take everyone through this morning, which is the expansion of the FMLA, the Family Medical Leave Act, as well as the federal paid sick leave law. Lastly, we're going to talk a little bit about how the FFCRA will provide employers with certain tax credits. Again, I know it's something that's been out there that people are looking for more information on, and the respect to those payments required under the new law. So that being said, let's get into some information about the emergency paid sick leave. The emergency paid sick leave, this requires employers, again, with less than 500 employees, up to 10 days of paid sick leave at the employee's regular rate of pay if they are seeking quarantine or seeking treatment as it relates to the coronavirus. There are no minimum requirements for days and hours to make an employee eligible. What that means to everybody is that all employees are eligible under this program. So when an employee is sick, employers should provide their full-time employees with 80 hours of paid sick leave at the employer's regular rate. Now, there is an exception for employers of healthcare providers or emergency responders to exempt these employees, at their disposal. So, however, the Act does include now language allowing the Secretary of Labor to exclude healthcare providers and emergency responders from the definition of employees, and to exempt small businesses, which would be those with less than 50 employees, of the leave if it would jeopardize the viability of their business. So next, just to touch on the part-time employees or irregularly scheduled employees, they are entitled to be paid based on the average number of hours the employee worked for the last 6 months prior to them taking the leave. So let's talk about some qualifying reasons and how that plays into the emergency paid sick leave. This portion of the Act actually has significantly changed since it was first passed by the House. The Act itself now allows eligible employees to take paid sick leave for the following reasons that you can see on your screen right now. It is important to make the distinction on these 6 reasons, right? The first 3 reasons are driven by the employee's own health or need to quarantine, while the last 3 reasons are driven by the employee's need to care for a family member, child out of school, or a catch-all provision, which is going to be number 6 on your screen right now. This is important because it directly relates to the amount of paid benefit that the employee will receive, and we're going to get to that on the next slide in just a minute. Also, another thing to note of importance, that caring for another person who is subject to an isolation order or self-quarantine is no longer limited to quote-unquote family members, and that's something new I wanted to bring to everyone on this call today as well. So, as I mentioned on the earlier slide, the 6 qualifying reasons are notable because the amount of the paid benefit eligible to the employee is different for the first 3 reasons versus those of the last 3 reasons. Under the emergency paid sick leave, for qualifying reasons 1, 2, or 3, employers should provide full-time employees with 80 hours of paid sick leave at the employee's regular rate. Or, for qualifying reasons 4, 5, and 6, employers should provide full-time employees with 80 hours of sick leave at 2/3 of the employee's regular rate. So, again, another significant change from the original bill is that this act does place limits on the paid sick leave. The benefits are capped at what you can see on the screen right now, which is $511 per day when the leave is driven by the employee's own need or own health or need to quarantine, and $200 per day when the leave is driven by the employee's need to care for a family member, a child out of school, or the catch-all provision, which is number 6 from the previous slide. So I'm going to finish up on the emergency paid sick leave portion just by talking about some additional rules that I felt were important for everybody just to be reminded about or to know if you weren't already aware. However, what I'm going to talk about now is the carryover, right? The paid sick leave will not carry over to the following year, and maybe in addition to any paid sick leave currently provided by employers. Also, the paid sick leave, paid sick time may be granted in addition to any pre-existing paid leave benefits. Furthermore, the employer may not alter any existing paid leave policies that they currently have in place with the idea of avoiding this provision. Paid sick leave must be made available for immediate use by any impacted employee regardless of their length of employment. Moreover, the employer cannot require that any employee first exhaust other paid leave benefits first. So previously it was understood that the DOL had the authority to exempt small businesses from the leave requirements due to a financial hardship. That's what we've read. Small businesses are those with fewer than 50 employees, but they really didn't provide much detail on that afterwards. And it was a hot question that we'd get quite often from clients and businesses that we spoke to. So again, it was unclear how this can be applied. So I will say, as of this past weekend, we did receive some clarification on these exemptions, and I want to take everybody through those right now in case you are unaware of them, haven't gotten the emails or had a chance to look into it. But with employers that have less than 50 employees, and again, this is what we're using to classify small businesses as it pertains to this legislation. Employers with less than 50 employees were not covered traditionally by FMLA outside of the EFMLA that we're talking about now. However, now they could be exempt from EFMLA and from one provision of emergency paid sick leave, but not all the provisions, and that's important to understand. What this means is that an employer is exempt from the paid leave under EFMLA and E-paid sick leave due to school or place of care closures due to coronavirus-related reasons, and that would be number 5 under the qualifying reasons from a couple of slides prior. Now, a small business may claim this exemption if an authorized officer of the business has determined one of the following. One, that the paid benefits under these 2 programs would result in a financial hardship for the business. And I'm kind of simplifying things for you because the way that they're written by the DOL is inherently meant to confuse people. Second, would be if it's determined that the absence of the employee would entail a substantial risk to the financial health of the business because of their specialized skills, their knowledge base, or 3, if it's determined that there are not enough workers who are able and willing and qualified to make up for the lost work due to employees being out. Now, again, the big change from before is that the Department of Labor first mentioned, or at least intimated, that they would have to provide approval for anybody seeking an exemption. But where that's changed is that it's essentially saying that now an authorized officer of the business or an organization can look at these rules and make that determination on their own. However, I am going to offer you a word of caution that while the DOL guidelines do seem to give the employer control over this determination, it does seem to be based off of some definable criteria. So if the DOL comes knocking on your door at a later date, you definitely want to make sure that you have the data to back up your actions if you're going to take or look into this exemption. So that being said, let's move on to the Emergency Family and Medical Leave Act. This act significantly amends and expands on the traditional FMLA as we know it on a traditional basis. The current employee threshold for FMLA coverage would change from only covering employers with 50 or more employees to instead covering those with less than 500 employees. So again, it significantly widens the gap of who is affected for this legislation. It also lowers the eligibility requirement for employees that have worked for at least 30 days prior to the leave, and that they may be eligible for the paid family and leave. So the 12-month and 1,250-hour requirement is also not applicable in this situation. As you can imagine, a lot more employers that weren't previously subjected to the FMLA now are going to be subjected to these rules. The expanded FMLA will also provide up to 12 weeks of job protective leave, 10 weeks which are paid, 10 weeks which are paid and subject to the cap, to employees that had a qualifying need related to the coronavirus. So this new type of leave can be used by an employee who's unable to work or telework due to reasons, a bona fide need to leave for care for a child whose school or child care provider is closed down related to the coronavirus. Furthermore, the FFCRA does not provide leave to an employee who is still able to telework. So let's talk a little bit about how this is going to work. There is a paid leave requirement for EFMLA. First 10 days may be unpaid leave. The employee may elect to substitute paid leave for EFMLA during the time. However, the employer cannot require the employee to use their PTO time. Also, following the first 10 days, the employer must provide paid leave in an amount that is not less than 2/3 of the employee's regular rate of pay. So again, there is a cap on this pay, $200 per day and $10,000 in the aggregate. So listen, I know a lot of us here are familiar with FMLA, or I should say traditional FMLA, and there are requirements around job restoration and reinstatement. There are with EFMLA as well, and that's what I wanted to talk to everyone a little bit on this next slide. So it really breaks it down to 2 different categories: employers that have more than 25 employees versus those that have less than 25 employees. Businesses with 25+ employees will have the same obligation as under the traditional FMLA regulations to return any employee who has taken EFMLA to the same or equivalent position upon the return to work. Conversely, employers that have less than 25 employees, they are generally excluded from the requirement if the employee's position no longer exists due to an economic downturn or other types of circumstances caused by the coronavirus during the time of the leave. This exclusion is subject to the employer obviously making a reasonable attempt to return the employee to an equivalent position, and requires an employer to make efforts to return that employee to work for up to a year after the leave takes place. So, those 2, up to this point, it kind of wraps up, the details behind the two different leaves. What I want to get to now is notice requirements. And I know that we've had a lot of conversations around posting notices, notice requirements. What does the DOL require? And I can say the DOL has recently updated their guidance around that. So just to start off about notice requirements, each covered employer must post a notice of the Families First Coronavirus Response Act in a conspicuous place on its premises, right? This is what we know, this is what we've been following, and if we're still in an office, then it's something that we should still follow. But understanding this may be difficult due to a lot of employees working remotely right now, the DOL has clarified on what to do in these situations. And what that means and what they've said is that employers can satisfy this requirement by emailing or direct mailing the notice or the posting to employees or posting it on their website. Either one of those options would be sufficient to check off that box according to the DOL. You're not required to post a notice in multiple languages. The DOL is currently working on translating the posting notice into different languages, and we're certainly keeping an eye on that and making sure we can get that out as soon as possible. You do not have to pay, or you don't have to provide the notice to recently laid off employees or to job applicants, but you are required to provide the notice to new hires. This is something that we've actively input into our new hire process, our electronic onboarding process. It's also something that if you're not following one of those processes electronically, you want to make sure that this note, this posting is included in your process. Also, very important, if your state provides greater protections than the FFCRA, employers still need to post this notice. It's very important. All covered employers are required to post a notice regardless of whether or not their state requires greater protections. It's always important to know you must comply with both federal and state law. And the notices need to be posted as of today, April 1st, which is the start date. So, I'm just about done to wrap up my piece and passing it off to my better half, Carol. There are a couple of other things I did want to touch on as we go through the next couple of slides. That would be the tax credits. This is something, again, I know that has been a buzz lately, and I wanted to provide some clarification around the tax credits as it pertains to EFMLA and emergency paid sick leave. So the FFCRA provides employers with certain tax credits for payments required under the new law. And I'm going to take you through those. So the paid sick leave time payroll tax credit. This can be claimed on an immediate basis with each payroll equal to 100% of the amount of sick leave wages paid. Now, where the difference comes in is that initially when notice came out, it was known that employers can apply or get these credits on a quarterly basis. Now, I think that the DOL understood that that doesn't really quite provide those credits or those funds back to employers in an immediate fashion. So it was clarified that this can now be done on an immediate basis with each payroll. So the credit is limited to $500 per day if an employee is taking time off to care for himself or herself. Again, first three bullets of those qualifying reasons. Or $200 per day if the sick leave is to care for an individual who's quarantined or showing symptoms of the coronavirus, or obviously a minor child whose school is closed. Similarly, the wages paid during EFMLA, a separate payroll tax provision allows for 100% credit against the employer's share of the payroll tax for each employee, limited to $200 per day. All right. In each case, the credits are refundable if it exceeds the amount the employer owes in payroll tax. So, listen, in an effort to streamline the tax credit purpose, I know Prestige has set up specific payroll codes within our PrestigePEO system designed to provide an immediate tax credit on your payroll invoice. And this is a good thing. The whole idea behind this is to eliminate any heavy lifting on our client's end, on the employee's end. We don't want you to have to do much. We want you to focus on retaining these employees and operating in a functioning business. So, obviously, anything we can do on our end is going to be at the service of clients and businesses. Lastly, to wrap this up, the FFCRA does not provide a payroll tax cut or an extension to standard filing deadlines for federal tax returns. However, the IRS separately has extended the April 15th deadline for tax payments. So, a couple things to keep in mind as we talk about state and local laws. Many of the state and local jurisdictions have their own paid sick days and family and medical leave laws, right? This we know. These are going to be in addition to these new federal requirements. Whether your own policies, whether they're state laws, local laws, they are going to be in addition to these new federal requirements. Many state and locals are working correctly to amend their laws or add new requirements as well. So these are also things that we are keeping tabs on as we push forward with these new laws. Detailed documentation and medical certification. The DOL has updated their rules. They provided new guidance on how they say employers must collect documentation in support of leave as specified in applicable IRS forms, instructions, or information. So to date, IRS hasn't released what that documentation is going to be, but again, something else that we're keeping an eye on. The DOL also says that employers can require workers to provide additional documentation in support of emergency FMLA that is taken to care for children whose school or place of care is closed due to coronavirus reasons. And lastly on this slide revolves around intermittent leave. The DOL has confirmed that employees may be able to take EFMLA or emergency paid sick leave intermittently while teleworking if the employer does agree to it. So if an employee is unable to telework their normal schedule of hours, an employer may agree to allow the employee to take paid sick leave on an intermittent basis while they are working on a telework basis. So lastly, there are some frequently asked questions I wanted to stick in here before we get to any towards the end. Again, these are generated by a lot of the questions that we field on a daily basis. One that seems to be pretty popular for the last few weeks has been what's the difference between a furlough and a layoff? The main difference between the two is that a furlough typically allows employees to return to their jobs. Some layoffs are temporary, but in most cases these are permanent terminations. So oftentimes furloughed employees often remain quote-unquote active in the payroll system, where a layoff is quote-unquote terminated in the system. So for purposes of paid sick leave or emergency FMLA, the DOL has provided guidance that appear to suggest that the agency equates furloughs to any layoff where employees are no longer working. And those are the important words to follow. Furloughed employees are not entitled to emergency paid sick leave or emergency FMLA, regardless of whether their employment has officially ended. The employee has to be working to be eligible. Next is the FFCRA retroactive. This is another common inquiry that we get as to whether employees can take paid sick leave under the Act prior to the effective date. So simply put, no. The FFCRA becomes active today, April 1st, and the paid benefits will start as of today. They will not be retroactive. Are employees that are forced home by shutdown orders excluded from paid leave? The DOL's guidance, basically, their guidance suggests that if employers send home workers and stop paying them, that they're not entitled to EFMLA or paid sick leave, essentially if the employer closes the work site for a lack of business or because it's required to close, due to federal, state, or local directive. This would be true whether the closure occurs before or after April 1st, obviously the effective date of the law, and even if workers requested leave prior to the closure. So similarly, I guess, if an employer closes its business while workers are already out on paid sick leave or emergency FMLA, it should still pay for any paid sick leave or FMLA leave before the closure. But it has no further obligation to provide emergency paid sick leave or FMLA as of the date of the closure. If I'm a small business with fewer than 50 employees, am I exempt from the requirements to provide paid sick leave or family or extended family and medical leave? So I know that we touched on this earlier. There's some information that is new about this, so I felt it was important enough to bring up again and review one last time. But a small business, and again that's a business with less than 50 employees, is exempt from certain paid sick leaves and EFMLA requirements if providing the leave would cause a hardship to the business. All right? This means that a small business is exempt from the mandated leave requirements if, one, the employer has fewer than 50 employees. Two, the leave is requested because the child's school or place of care is closed due to coronavirus-related reasons. And three, if an authorized officer, as we discussed earlier, because companies do have a determining factor in this as well, if they have determined that at least one of the three conditions described earlier is satisfied. So last question I have for you before I pass it off to Carol is, I have an employee out sick now. What do I do? First thing you should do is get a doctor's note. Determine why they are out. If, based on the information you get back or the certification, they are out for a qualifying reason, you can apply the applicable state or federal benefits in that situation. So I am going to wrap up my part of this, the webinar today and pass it over to Carol.
All right, thank you very much, Jason. We'll move to the next slide for me. I will be asking Jason to do that. He has control of the slides. So my responsibility today is to talk about the CARES Act. The CARES Act is officially named the Coronavirus Aid, Relief, and Economic Security Act. It's always good to have a good acronym when you come up with legislation this big. So it is the CARES Act. It went through the House and the Senate last week, and it was signed by President Trump last Friday. This is the second piece of legislation, as you've just heard about the first, that has been passed as a result of the coronavirus. This one specifically is meant to provide relief to individuals and businesses that have been affected by the outbreak. Now, as I mentioned, this is a very large piece of legislation, 355 pages to be exact, so we're not covering all the aspects of it today, but here's the key points that we're going to cover today. There's an SBA Paycheck Protection Program loan, a deferral of the employer share of the Social Security tax, being called a payroll tax holiday now, a payroll tax credit for employee retention. They've expanded the unemployment system, direct payments to individuals, which has been all over the news, and some new rules regarding the 401k plan. So the SBA Paycheck Protection Loan Program. It is a new loan administered by the SBA, the Small Business Administration, that has the starting qualifier as these are for employers with less than 500 employees. Now, they recognize that specifically businesses in the hospitality industry may have more than 500 employees overall, but when you count their individual locations, each of those locations has less than 500 employees. So they have made the exception that as long as the locations have less than 500 employees, the business will qualify for this loan program. There are some other eligibility guidelines that typically the SBA has for loans that they issue, and those have been waived under the provisions for this specific loan program. So what can this loan be used for? This loan is meant to be, in essence, a bridge loan to get you through what is going to be a particularly rough time over the next 8 weeks. And it can be used for payroll costs, the cost of the health care for your employees, rent, utilities. If you have interest on other loans that were taken out prior to this economic downturn, the money can be used for that. The only thing this money cannot be used for is any of the payroll costs attributed to the special leave payments under FFCRA. Those already have very generous tax credits associated with them and therefore are not eligible to be paid for by these loan proceeds. So how do you determine your loan amount? The federal government has said that this loan amount will be based on your average monthly payroll costs for 2019. Now, what is a payroll cost? It is a lot of things. It is wages, commissions, tips, the cost of the benefits, 401k match, state and local taxes that you might pay. All of this is rolled up into an amount deemed as payroll costs, and it will be capped at $100,000 per employee. You take that monthly average cost from 2019, multiply it by 2.5 with a cap of $10 million. Now, this may seem like an arduous task to determine what was my average monthly cost for 2019. Well, Prestige has got you on that. We have a report that your payroll specialist will be able to run and send to you that does just that per employee, so you can see the breakdown, you can see who's capped at $100,000, and it calculates your loan amount for you. Now, the federal government has added a very nice forgiveness provision into this loan. The loans will be forgiven up to the amount that you spent on the qualifying costs that I had mentioned in the earlier slide. Payroll costs, rent, utilities, those items. There's a couple of other caveats in this forgiveness. The first one being the size of your workforce in the 8 weeks after you've received your loan compared to the same 8 weeks in the previous year. If you have reduced your workforce in this 8 weeks compared to the last 8 weeks, that will reduce your loan amount. So, for example, let's say for the next 8 weeks, you have 8 employees. Same time period last year, you had 10 employees. They develop a fraction, 8 over 10. Your loan forgiveness amount is now only 80% of your original loan amount. The second caveat, it has to do with the salary and wages for each individual employee. If any single employee is reduced by more than 25%, that directly reduces your forgiveness amount. So let's say you had Susie. Susie, for 8 weeks last year, was paid $40,000. For the same 8 weeks this year, after you've received your loan, she's only paid $20,000. It does not matter the reason why Susie makes less money. You could have developed efficiencies between last year and this year, but her reduction in pay will affect. So the reduction is more than 25%. It is $10,000 more than 25%. So that will reduce your loan forgiveness amount by another $10,000. So if we had started with a $100,000 loan, 80% was forgivable because of the first caveat, so we're down to $80,000. Now you need to subtract another $10,000. So your $100,000 loan will only be forgivable for $70,000. The remaining $30,000 converts into a 2-year loan with a very low interest rate. I believe I read just recently when the application came out, which I'll speak to in a moment, at only 0.5%. So that explains the forgiveness portion. The application, which cannot be filed until April 3rd, Friday, but the application itself is out. We couldn't really embed the application into this presentation, so we've provided you with a live link to see the 2-page application for this loan. The loan application requires basic business information, a list of owners that own more than 25%, some of the usual attestations that no one's been committed for a crime, we're going to use this loan for the appropriate costs, and that's it. There is no collateral required, there's no personal guarantees. That is the loan application. So you can take a look at it later today after our webinar and get that process started. We will be teaching the payroll specialists shortly after this webinar how to run that report, and you will have everything you need to apply for this loan. So the next item that we're going to talk about is the deferral of the employer's share of the Social Security tax, that payroll tax holiday. Employers may elect for the rest of 2020 to defer the employer's portion of the Social Security tax through this year. That lump sum at the end of the year is then paid in 2 installments. Half is due at the end of 2021, The other half is due at the end of 2022. Keep in mind, if you elect this option and you also get an SBA loan that is then forgiven, you're no longer able to defer the employer share of the Social Security tax, and anything that was deferred is due to be paid immediately. So keep these things in mind of how these different items work together. Next slide. The third thing is the employer payroll tax credit. It's being referred to as a retention tax credit. It is available to anyone that was conducting a business in 2020 and in respect to any calendar quarter. So this is a quarterly tax credit calculation. If your operations were suspended due to the virus, or you simply experienced a 50% decline in your gross receipts compared to the same quarter last year. First example for that will be restaurants. They haven't been shut down, but they're on takeout only, so even though they're up and running, they're not suspended, their gross receipts are certainly less than the previous year. What is the credit? 50% of qualified wages with respect to each employee for the quarter with a maximum of $10,000. So that means qualified wages, the tax credit for each employee could be up to $5,000. What are qualified wages? Well, it depends on the size of your company. If you have more than 100 FTEs, and that stands for full-time equivalents, wages paid to employees that you're paying solely to retain them qualify for this tax credit. If you're an employer with less than 100 FTEs, it is all of the wages paid. So the requirements are a little looser for the smaller companies, because if you have 100 FTEs, any wages you pay providing services qualify for the tax credit. But if you have more than 100 FTEs, it's only those payments that you are paying out to retain employees who are not providing services to you. You're also allowed to include the qualified health plan expenses that go along with those wages. You cannot include the wages that were paid under FFCRA. Those already have a very lucrative tax credit associated with them. So what is this tax credit used for? It's taken against the employer portion of your Social Security taxes. If at the end of the quarter you have more credit than what has been assumed by your employer side of the FICA taxes, there will be a refund process to get that money back to you. Tax-exempt employers are eligible for this tax credit. You will not be able to get a double benefit for the wages paid under the family and medical leave, as mentioned before. And you are not eligible for this credit if you receive the Paycheck Protection Loan. So the thing to keep in mind, we have talked about 3 separate programs: the SBA loan, the tax deferral, and the tax credit. And you have to evaluate all 3 of these before you decide which one you want. If you get the SBA loan, you cannot take this retention credit for possibly all 3 quarters of this year. And if you have a loan that is forgiven, you can't take the tax deferral. So it's important that you evaluate all 3 of these before you make your choice. The CARES Act has also expanded the unemployment program. The #1 improvement to this is that unemployment will be extended for an additional 13 weeks above and beyond the standard state unemployment that has already been in place. This also allows individuals who have never been eligible for unemployment to collect. Specifically, self-employed individuals, independent contractors, people that are a part of the so-called gig economy. Those people will be allowed to register for and qualify for these unemployment tax payments. The last huge benefit is the federal government will be funding the weekly tax payments by an additional $600 through July 31st. So that is the improvements to the unemployment. The next thing is, this is what's been all over the news, or the direct payments to the individuals. There are many qualifying factors on these. Their income phase outs. Children under the age of 17 affect the amount. I do know that these amounts, if you have filed your 2019 return, will be based on your 2019 return. If you have not yet filed, and that could be many people because that filing date has now been extended to July 15th, these tax payments will be based on your 2018 return that the IRS already has and processed. If you have elected direct deposit for your refunds on either of those returns, this money will be direct deposited into your account. Otherwise, they will be mailing paper checks. It's my understanding that they are going to try and get those checks out in 3 weeks. We will wait and see. The last thing we will talk about today is the changes to the 401k rules. There is a new special emergency coronavirus distribution that allows participants to withdraw up to $100,000 from their 401k plan. This specific distribution will not be subject to the typical 10% penalty that is charged on early distributions out of a 401k. The income tax that is due on this distribution is typically paid in the year the distribution is taken. Federal government, recognizing the financial hardships, has said you may now spread that income tax liability over 3 years. You can reduce this income tax by refunding this distribution back to your 401k. You have the entire 3 years to do it. And you can do this outside of the standard 401k funding caps that are in place every year. If at the end of the 3 years you've been able to fully fund this amount back and you have paid income tax in the previous years, there will be a method for you to get those income taxes refunded. There are no details on the specifics of that yet. When you request your distribution, our 401k provider, and I believe this will be similar across the board with all providers, has a standard default that you will have a 10% federal withholding from your distribution. If you do not want that, you will need to elect to waive that income tax withholding, and then you would get the full distribution amount. The last thing that they have updated is that the required minimum distribution requirements have been waived for 2020. Unfortunately, the stock market is at a very low point at the moment. The federal government doesn't want people liquidating holdings specifically so they can take this required distribution. Now, as I mentioned, this is a very large piece of legislation, and we have only touched on a fraction of it. I would advise everyone that it's listening to please check with their accountants for other advantages and things that have been built into this, specifically rules regarding your net operating loss or NOL carryforwards and carrybacks. There's a change in the interest expense limitations, and there's also been a correction regarding the Section 179 and depreciation expenses for qualified improvement properties. So again, please talk to your tax accountants regarding all of these changes. And on that note, I turn this back over to Jason.
Thank you, Carol. All right. So, listen, that really wraps up a big portion of what we're doing right now in terms of educating everybody on the FFCRA and the stimulus bill, or the CARES Act. So I'm really happy that everyone was able to join us today. Now, I will go through, or Carol and I will go through some questions. But before I do that, I do need to lay down some ground rules here. First of all, please, if everyone can remain on mute, so that we can avoid the chaos of so many people talking at the same time. We will get through some of these questions. There are going to be things that we can answer and some things that are a bit more fluid that we may not have the answer to, but I can promise you we will address it and get those answers back to you very quickly. The other point, too, is that I have to give a big shout out to our COO, Eric Fudum, who I can see has been furiously responding back to a lot of questions, and thank you for that. So with that being said, I don't want to repeat a lot of questions that may have already been asked and answered. So we will highlight a few of these questions as as we go through this, but I will also mention that we'll go through the copy of the chat. Make sure to grab all those questions that you have and get those out to everybody answered in the quickest way possible. All right, so I'm going to go through a few questions here before I wrap up. One thing that we see came through is, do we have to pay furloughed employees for sick leave and emergency FMLA since they are still technically active in the system, right? I think we covered this on a couple of the slides, but towards the end, no. Furloughed employees are not eligible for these benefits. Again, the employee has to be working. If they are furloughed but still active and not working, they are not eligible for these benefits. So, all right, let's take a look here. Another question that came through. Can the family leave provision be taken intermittently, say 3 days a week? So say 3 days a week leave and 2 working remotely. So the DOL has confirmed that employees can take both emergency paid sick leave and EFMLA intermittently while teleworking if the employer agrees, which is important. The employer does have to agree. Let's see through here. And I also give a nice thank you to Harland Lundy, who definitely helped out in gathering a lot of these questions and coordinating this for us. So, are we required to offer new mandated 80 hours of sick leave if we already offer 80 hours of sick leave? Yes. This is an additional allotment of sick leave that's mandated by the federal government related to coronavirus PTO. So PTO and sick allotments would be treated as separate time off available to an employee. How do the emergency paid sick leave and emergency FMLA interact with each other? That's a great question. The first 10 days of EFMLA are technically unpaid. However, employees may elect to fill that unpaid time off with an 80-hour allotment of emergency paid sick leave and then take emergency FMLA. Who pays for the emergency PSL and emergency FMLA? The employer pays for both the emergency paid sick leave and the emergency FMLA. Again, this is going to be done through your payroll, through specific pay codes that are set up specifically in the Prestige system that we can then use to report going forward. Let's see here. We have a couple for Carol.
All right.
Make sure that everybody can hear at a safe distance. Will Prestige be able to track tax credits and tax deferrals?
Absolutely, we will. I can say for the FFCRA tax codes, which we are going live with this week, are already pre-set up to roll up into an automatic reduction on your invoice based on the tax credit limitations as they're laid out in the law. As for the retention tax credit and the payroll tax deferral, we are not there yet. We still need some time. As you all know, this was released on Friday, and there are a lot of software and programming issues that need to be dealt with. We will have it in place, and there will be a process for any deferrals or credits that we're not ready for. Should you have an immediate payroll, it will be fixed or taken into account on a follow-up payroll at that time. So yes, we will be fully equipped to handle all of this for all of our clients.
All right. How is Prestige going to push out information to all of the clients about the ID to use, period to use, Form 941 availability?
Let me read that again. Okay, I'm guessing that's, and I apologize because I'm not really sure. I'm guessing you're talking about the CARES Act in terms of the SBA loan, what period to use for your payroll costs, and the fact that typically things like this require copies of 941s. As you may or may not know, the 941s have our name on it, not yours. We have generated a report that has our name on it and your name on it with all of the payroll tax costs for 2019 as regulated in the law that you will be able to include with your application with the SBA.
So I guess I can add on to that also, Carol. You know, we have a big initiative within Prestige to communicate, maybe even over-communicate to our clients at time about all of this information. So through webinars, through our constant communications, and certainly through direct contact with your support team, your Prestige dedicated partners, especially the HR business partner, this is how we're going to get this information out to our clients. It is important that we provide you the support that you need to get through this, understanding that your job is to run your organization. Lean on Prestige for that, but obviously we're going to be proactive about getting this information out to everybody on this call.
Jason, I'd like to address, I've seen a question, it says, are business owners' wages excluded from the tax and loan programs discussed? Depends what you call wages, and I find that some people get confused in that. Any amounts that are reported on a W-2, so an S Corp owner's wages or a C Corp owner's wages, all of those wages are eligible. There has been no cap on that other than the $100,000 being the cap for the total amount that can be calculated in that. So they are not excluded. If you are a partnership getting draws, that is not included in this calculation. Another question had to do with when will the payroll reports be ready? It is in place. It has been fully tested. We just need a short period of time to get that out and teach our payroll specialists how to run it. Applications cannot even be filed for this loan until Friday, so we will be able to get that report to you well in advance of that filing deadline. There was another question about gross receipts. How is that defined? I will say at this point, gross receipts is going to be line 1 on your business income tax return. That is your gross receipts, gross revenues. That is typically what the IRS means when they say things like that.
All right. All right, so we're coming up on the hour here, and I'm going to wrap things up with everybody. I really do appreciate, it looks like it was informative for most everybody. If not, then, you know, we can definitely take that direction for the next time. But I do want to touch on a couple things before we wrap up here, which is just on this last slide and deals with support that you can receive. So listen, Prestige is working really hard to get this information out to everybody as soon as we can. Please continue to utilize your Prestige support specialists for daily support. That's what we're here for. We want to make sure that everyone does feel covered and supported every single day. We will also continue to send out weekly email updates to all clients. I hope those have been informative for everybody as we try to scrounge up every piece of data for you so that you can be well informed. Any responses that come back from those emails go directly to me and are dispersed out to the HR business partners and the remaining support staff. So understand that they should be addressed immediately. Also, if you want to visit our newly updated Prestige website, and please urge that you do, you will find our online resource center using the URL listed on the screen in front of you right now. All of our updates regarding the coronavirus outbreak can be found in the Resource Center, as well as a ton of information as it pertains to other areas such as payroll, tax benefits, state and federal compliance, and quite a bit more. Lastly, should you need immediate assistance, you can always utilize the new Prestige Go mobile app, which has been rolled out to everybody, for a direct link to your dedicated support team. So again, thank you everybody. It was a pleasure having the opportunity to speak with you this morning, myself and Carol. And if you have any questions whatsoever, please reach out to us.
How come I can hang up?